Good afternoon, everyone. Welcome to Senate Utilities Committee, and we'll continue our hearing on Senate Bill 353 today. For those of you watching online, you can go to the Senate, the kansaslegislature.org site, look for the committees, standing committees, and look for utilities. We're on page 2, and if you look for the committee testimony, you can click on there. The date will be highlighted. You click on that, and you'll be able to see the downloaded testimony from our conferees today. We're going to start off with a quick overview, just a quick reminder of what Senate Bill 353 contains from our reviser, Nick Myers. And Nick, I'll give you the floor.
Thank you, Mr. Chairman. Committee, you'll remember that Senate Bill 353 deals with construction and operational requirements of wind facilities and some health and safety requirements with when you're applying and for construction of one of these facilities. The main couple things I want to point out that you'll remember from yesterday is this bill would provide certain setback requirements for construction of these facilities. Those setback requirements would be 10 times the system height or 5,280 feet, whichever is greater from certain property lines. So those property lines would be non-participating landowners, public buildings, airports, federal wildlife refuges, public hunting areas, or public parks. If you remember also, this would require an operator, a developer of one of these facilities to submit an application with the Board of County Commissioners in which that facility is being proposed, or in the Board of County Commissioners or at the county that contains any land within that setback distance of 5,280 feet or that 10 times the system height. And there's specific application requirements that would be required, including notice, certain demonstrations of mitigating decibel levels, and some other application requirements. In addition, there's some requirements relating to a developer's intent to build industrial wind turbines, and that would impose some additional application requirements under the bill. So the developer would be required to do a shadow flicker assessment, some risks assessments, and some other kind of health and safety assessments and plans and measures to ensure that the facility is operating in a safe and reasonable manner. The Board of County Commissioners would be required to apply and approve an application after it holds a public hearing if the developer complies with all the requirements. And if you remember, the Section 2 of the bill deals with the current operation of wind turbines in the state. So current facilities that are operating would have to operate such facilities so that no residential dwelling would be experiencing shadow flicker upon that residential dwelling, and a resident under this bill would be able to petition a developer or an owner or operator of a facility to eliminate that shadow flicker. Finally, the bill with regard to current operation of facilities would require that owners or operators of those facilities be adequately insured to insure against the risks that are associated with the operation of these facilities. And Mr. Chairman, I'd be happy to stand for any further questions today on the bill.
Thank you, Nick. Any questions from the committee? Seeing none, I think we'll go ahead and proceed. As with yesterday, we will allow 5 minutes for each person to testify, and we'll start with neutral oral testimony. First from Jay Hall from the Association of Counties. Jay?
Thank you, Mr. Chairman. Jay Hall for the Kansas Association of Counties. I will be very brief today. I don't need a whole lot of time. I just want to make 2 quick points. I'll start by saying that KAC has held that the decision on whether or not to have wind projects is a local decision for local officials to consider and for individual landowners to decide whether or not they want to participate. As it regards to this particular bill, I think it needs to be clear that existing facilities should be grandfathered into this because obviously those facilities already exist. And so there's some language that says no facility shall be constructed, but I just like to be explicit that existing facilities are grandfathered in. And then secondly, as it relates to the letter of credit for the decommissioning of facilities, I want to make sure that, counties don't have on their staff somebody that is in the space of decommissioning these types of facilities. So some clarification on how we would go about doing that would be helpful in this bill. But other than that, as I said, we're neutral on the remainder of the bill.
Thank you, Jay. I think I've got one more neutral conferee, I think. If Brad Lovas is here from the Department of Wildlife, I don't see him here yet. I know he was testifying. Committee, do you have any questions for Jay since he is here? I do have one. Well, Senator Francisco, I'll let you go.
Thank you, Mr. Chair. I know that you made this statement about, counties that already have established those. It should be clear that those are exempt. And yet, Section 2 clearly relates to those
Yes.
establishing requirements. Did you have any comments on Section 2 and those
And
requirements?
Section 2, and I would have to look direct, let me pull up the language really quickly. And I will give you comments specific to Section 2. Page 5.
Page 5 of the bill, right, line 41, I think, Jay.
Yeah, are you talking about the shadow flicker and things like that? Yeah, we have no issue with developers running additional tests or things like that. What we don't want to see happen, obviously, is for existing facilities to be required to be removed, because obviously at that point, the landowner has made an agreement. The county oftentimes has a payment in lieu of taxes agreement in place, and so we don't want existing agreements to be damaged by the language of this bill. And so that's really what our concern is just that those existing facilities would be grandfathered to avoid any issues with any of those agreements that already exist.
Okay. With regard to that, particularly with shadow flicker, there are mitigating things that can be implemented by the existing turbines. Obviously, the setbacks are a different story. You can't move a turbine once it's there. So I think it was meant to be perspective for the setbacks, but perhaps allow for mitigation of shadow flicker for the existing turbines. Would that be?
And we don't have any problems if they're required to do mitigation efforts or things like that. It's just more of we don't want to move turbines because that's a very involved process.
Yeah, that wasn't the intent.
Okay.
Yeah, but if you see some language that might be clarifying, we can work with the revisor to make sure that the perspective and grandfather sections are more clear.
Okay, yes,
Okay,
we would
very
appreciate
good.
that.
Any other, Senator Fagg, sorry about that.
Thank you, Mr. Chairman. Jay, thank you for your presentation. I was wondering if the Kansas Association of Counties, do they have sample policies and try to help counties through this type of thing?
We do some classes on the conditional use permit process, obviously not just for wind turbines, but for a variety of uses because, you have conditional use permits for a lot of different things in counties. And so we have sample processes for that procedure, which would encompass wind turbines.
Thank you.
Seeing none other, I think we're good. Thank you, Jay, appreciate
Thank you.
that. I still don't see Brad Lovelace yet in the room. When he comes in, I might slip him in, but I think we'll go ahead and continue then with the opponent oral testimony. First up is Rorick Peterson of EDP Renewables. Rorick, welcome to the committee.
Thank you. Good afternoon, Mr. Chair, Mr. Vice Chair, Madam Ranking Member, members of the committee. Really appreciate the opportunity to be here today. My name is Rorick Peterson. I am the Director of Development in the Central Region for EDP Renewables North America. We're a large developer, owner, operator of renewable energy generation. We're the fourth largest owner, operator of wind farms in the U.S. That includes a pretty significant presence here in Kansas. We have our 201 megawatt Meridian Way wind farm in Cloud County that we built in 2008. Our 199 megawatt Waverly wind farm in Coffee County that we built in 2015. And most recently, our 199 megawatt Prairie Queen wind farm in Allen County in southeast Kansas that we built about 3 years ago. I'm based in our office in Overland Park. I'm a lifelong Kansan, and I really appreciate the opportunity to be here today to speak respectfully in opposition of Senate Bill 353. In my written testimony, I detail several key issues and problems with Senate Bill 353 as drafted, but I wanted to speak today a little bit in detail about the development process and really the operational reality of wind energy in Kansas. With all due respect to the proponents of the legislation, this legislation really is intended to address issues hypothetically attributed to wind energy that have largely not been realized in roughly 20 years of utility-scale wind energy operations in Kansas. Again, respectfully, the concerns expressed by some in support of the legislation have not been realized in countless communities in Kansas and elsewhere that are home to wind farms. Had that been the case, EDPR and other developers like us could not have successfully gone back to existing wind farms and built additional phases on those wind farms had those problems been routinely experienced by those communities, sometimes years after the first phase was constructed. As I've often communicated, the development of any wind farm is an involved process. Several stars have to align for any project to be realized. This includes landowner discussions, securing landowner agreements through numerous landowner meetings, community town halls, and open houses, numerous environmental, meteorological, and engineering studies and evaluations. Of course, the ultimate securing of land lease agreements with sufficient landowners that are contiguous. And of course, the incorporation of setbacks and siting guidelines into the ultimate design. As a result, the identification of specific turbine sites that can be engineered in advance to construction actually comes late in the process. We can have conceptual layouts early on in the process, but the final wind turbine layout is only realized after securing contiguous land control, incorporating the science of meteorology and engineering into the process, and of course, setbacks and siting restrictions. The notion that any wind farm is sited without incorporation of setbacks is untrue. One of the conferees yesterday said, and I quote, "We really don't have anything referencing the existence of setback regulations," and frankly, that's just outright false. Many wind farms are developed and constructed in Kansas where local setback restrictions mandated at the county level exist. But even where formal setback restrictions are not present, developers routinely incorporate industry standard and best practice setback policies and practices to ensure responsible siting of wind farms. I'll also note that our customers and our financiers obligate us to site our wind farms and wind turbines in a way that is consistent with best industry practice, formulated through many years of development and operation of wind farms across the country. To be clear, we are not anti-setback. EDPR has plenty of history working with and in counties in Kansas and elsewhere with reasonable siting restrictions and regulations that have been established. And in those cases, those are based on real-world operational and real-world experiences of the communities with those wind farms. In counties in Kansas where setback and siting regulations have been established, and there are many, those counties formulated those setback restrictions and ordinances through a considerable level of prudence and diligence. That was certainly our experience in Coffee and Allen counties. County officials took the time to do their research, to consult with other counties where ordinances were in place and where operational wind farms had already been present for years. And frankly, I find the testimony dismissive of the capabilities and the capacities of county commissioners and local officials rather perplexing. They have routinely taken us to task and held us accountable. There is plenty of precedent for this. In my experience, counties have routinely consulted with one another on the issues. The resources are there. Again, this isn't a new thing. We've been doing utility scale wind in Kansas for over 20 years now. Now, a few issues specific to 353. The setback restrictions and siting limitations are grossly excessive, devoid of any supportive safety or scientific basis. There are significant issues with, despite some of the testimony yesterday, how these restrictions cannot be waived by the landowner or homeowner. There are several siting restrictions in this bill where there's no indication of a waiver referenced. The provisions tied to decommissioning, particularly the inability to account for salvage value and the estimated cost.
Got about 30 seconds.
All right, thank you. In the decommissioning and the requirement that any provision of financial security be in an amount equal to 25% of the cost to construct the wind farm are wholly inconsistent with the common requirements associated with decommissioning. There are issues tied to the use of airports, including private airstrips that are frankly not real, and the definition of public parks in this bill is problematic as well. To wrap up, to my knowledge, this bill, if it were established and put into law, would make Kansas one of the most, if not the most restrictive states in the nation with respect to wind energy siting. Nothing like other states nearby, Oklahoma, Texas to be examples. So thank you for your time. I appreciate it.
Thank you very much. Committee, we will hold for questions until after all the conferees. And up next is Christopher Olson, Senior Environmental Scientist for Olson Environmental Health Management.
Thank you, Chair Thompson, members of the committee. My name is Chris Olson. I hold a PhD in environmental health, and every day that I come to work, I'm looking at issues like contaminated sites. I work with oil and gas companies. I've done coal-fired plants, gas-fired plants, and over the last decade, I've been involved in the renewable energy business. Over those years, I've led research teams published in the peer-reviewed scientific literature on proper setbacks in order to afford protection of public health and safety. I've appeared before similar Senate committees in North Dakota and Indiana, and I was the consultant of record for the state of Vermont on their health basis when they were putting in their proper siting guidelines. Thank you for allowing me to appear before you today to talk to you about my serious concerns about setbacks, sound levels, shadow flicker, and the like that are currently contained within Bill 353. There's no question that putting a state level or even an ordinance level, county ordinance level siting guideline in place is a complex and challenging process, one that needs thoughtful discussion and debate, where you're ensuring protection of public health and welfare while making sure that the setbacks and other requirements are reasonable. You've heard over the last number of days from Drs. Johnson and Punch and Mr. James. These gentlemen are known to me. Unfortunately, we don't share the same views, which you'll see from my written testimony, nor will you see that come out from many other counties or states where they've testified in the past that have not adopted their recommendations that they put forward to you. Specifically, I've worked in 8 counties here in Kansas over the last 5 or 6 years with developers while trying to set ordinances and coming up with the rules, if you will, both with planning and zoning commissions as well as with county commissioners in the CUP process when dealing with setbacks, sound levels, and shadow flicker, both in zoned and unzoned counties. It's not true that in an unzoned county there are no rules for wind turbines. In fact, the developers that I've worked with in the past work with the unzoned counties, county commissions, to make sure that those rules are in place prior to even having the road use agreements. It is true that there are many states across this country that have state-level siting guidelines. None of them come anywhere close to the unresponsible, unwarranted setback and sound and shadow flicker requirements that are put in front of you in this bill. Quite simply, and I'm not here to advocate that you put any more wind turbines than the 3,500 you already have across the state. But what I can tell you from my experience, you cannot site a wind project anywhere in Kansas or anywhere in the States for that matter at a 1 mile setback, 10 times turbine height, or a 35 decibel sound limit, or even a shadow flicker of 0 shadow flicker across non-participating properties. I've given you in my testimony, my written testimony, a very brief overview of some of the scientific supporting documents to that, but let me hit on a couple. Dr. Johnson raised the issue around worry about sound levels, sleep, and then cardiovascular. This is a true concern. This is why we have sound limits, not just for wind turbines, oil and gas. We have it for highways, we have it for airports and the like. And the difference is, and where we disagree, myself and Dr. Johnson, is that there has been 20 years of research specifically looking at sound levels and sleep. The sleep studies that have been conducted by Health Canada, by the Australians and others around the world, simply show that up to 46 decibels of sound, and I believe it was Mr. James or Dr. Punch said that I would be telling you this. It is true. Health Canada says that you can have up to 46 decibels. Why 46? Because we just simply didn't have turbines that were louder than that in that study. That study was not paid for. It was not participated in by developers. That study was done independently by Health Canada, which is the equivalent to your CDC. more reasonable sound limits that we know that work both in Kansas, in your neighboring states, and then are in state legislation are between 45 and 50 decibels. It ensures a good night's sleep for the homeowners.
I have 30
and it-
seconds.
Yeah, and it allows for, that. Shadow flicker, we have studied the health effects of shadow flicker. It is not a health concern. Somebody raised yesterday about epilepsy, shadow flicker. We have 2 of the world's leading epileptic researchers in the UK studied this. There should be a limit for nuisance. That limit that is typically employed is 30 hours at a home. I could go on about annoyance and other things, but quite simply, Senators, the take-home message that I would like to leave to you is that there is considerable research over the last 20 years that has studied this topic. The setback, the sound, shadow flicker, and other provisions in this bill are far more excessive than any other state in this country. Any of the local ordinances that have worked for 20 years in your state in particular. And with that, thank you for your time and happy to answer any questions.
Thank you. Next up, Alan Claus Anderson from Polsinelli. Welcome back to the committee, Mr. Anderson.
It's good to be back. Chairman, Vice Chair, Ranking Member, Committee members. Again, I'm Alan Claus Anderson. I am the Vice Chair of the Energy Practice Group at Polsinelli. We work on projects and policy issues around the country. I am also Adjunct Professor of Law at the University of Kansas Law School, where I teach renewable energy law, practice, and policy. For my students that are watching, we will be talking about this bill, so this gives us lots of good opportunities. So I appreciate that at least. The first thing we have to state about this bill is it's not about creating health and safety standards. We also have to be blunt and honest about the fact there are 8 bills all on the same topic that could be done into 1 or 2 bills, and they have the same goal, and that is to end renewable energy in Kansas. There should be no confusion about that. These bills are actually conflicting with each other, and we wouldn't have a series of them like that if it weren't an attempt to try to slip these one past a committee such as yours. And we'll get into the specifics of this that I think should concern you. So the one thing this bill does add that is different, and it was already referenced, it adds a retroactive application to current projects. You all are the Utilities Committee, and I don't think anything has been brought before you to understand what impact that would have. It will eliminate some level of renewable energy production, which is just simply electricity production in the state of Kansas. How much? We don't know. The author has no clue. I don't know what that number is. What would that do to reliability? I don't know. The author doesn't know. None of us know that, and it's not contained in this bill because it can't be answered. So the fact that we have retroactive application that will shut in energy production and we don't even know the impact ought to be enough to really alarm you as it relates to these bills. Similar things are in this bill that are also meant to meet that same goal. What this bill actually does, and you all know it, is it takes away local control from the counties. If any county wanted to pass these same things, they can, and they know how to do it. They know how to put these things in place. There's Association of County Commissions here, or counties. The county councilors in the state are fantastic. They know how to do this, and they know how to get outside help to the extent they have any questions. It would also force a sloppy version of zoning, and a faux zoning on unzoned counties, because it's going to create a requirement for them to process an application with a myriad of requirements that have to be reviewed, some of which fall within the federal arena. And in that federal arena, they don't have the wherewithal to do that. So they're going to have to now take this unfunded mandate, create this application, and know how to process it and review it. And before we say, oh, it's not a big deal, you can do this super easy, not going to be very expensive at all. Understand, when we add levels of restriction on property rights, we are harming the property right. When we harm the property right, we must do that deliberately and with due process. And we know that because it's contained in the U.S. Constitution and the state constitution. Before we deprive them of property, we must give them due process. I don't think anyone thinks this bill even remotely is due process. The fact that we have just a few minutes to even get into all the intricate problems of this bill tells you this isn't due process. Next, we have an attack on the freedom of contract. This bill is going to put requirements that have to be written into private contracts, and the terms that are contained and required in that, which I'll try to get to, are exactly the reason we don't have Topeka writing contracts for people in the counties, because it is amazing what's in that. And of course, when we take property rights and when we take away the freedom of contract, it is an attack on free market capitalism. There may be no worse bill for free market capitalism than something like this and the other 8 bills. So now I'll briefly get into a couple of the items contained in the bill because it's obviously so little time. So the first part we've already talked about, it overrides zoning and creates a zoning process in counties. And we've already talked about Dr. Olson on the specifics. The one I'll mention, airports. That sounds great, right? We should have a setback from airports. And of course, that's why we have the FAA to regulate that. What this is not airports. These are the sham ports. This is if I think I might, maybe someday, kind of think, possibly, maybe I do an airport, it now is an airport. And have to set up 1 mile setback, right? That's not a 1 mile setback. That's 1 mile setback in every direction. That creates 9 square miles of property rights taken away from their neighbors. 9 square miles. Same thing from non-participating landowners. So one person who says they may or may not do an airport, someday possibly,
30 seconds.
9 takes that away. But again, yesterday, I'll just mention this, and I hope the retroactive part I won't get a chance to get back to. Nuisance. Someone said, oh, they'll never talk about nuisance. Absolutely, we'll talk about nuisance. If someone thinks that any of these projects actually create a nuisance, they have all remedies of law. They have access to the courts. They should do it. They should absolutely go get legal counsel and talk and see if there's a nuisance. The answer is these projects have gone really well in counties, and that's why you don't see that. But they have every access to the court on nuisance that they want. And so that is not prohibited. And I'm available for questions.
Thank you, Mr. Anderson. Next up, actually, I'm going to jump ahead to Brad Lovas, who came in. Apologize, I skipped over you there, Brad. He's got neutral oral testimony from the Kansas Department of Wildlife and Parks.
Yep.
Thank you, sir.
Thank you, Chairman Thompson, members of the committee. And believe me, you shouldn't be apologizing to me. I had to testify at 1:30 in another committee, so I appreciate your allowing me to step in. I am Brad Lovas, Secretary of Wildlife and Parks, and I'm here to present neutral testimony, basically to just provide some suggestions to you on this bill. Basically, comments, and I heard it reflected in an earlier conferee, public hunting area and public park those are both broad terms that we would recommend we narrow a little bit. Wildlife and Parks is concerned with the language in the bill under Section 1, subsections E and F that provide a setback distance from public hunting areas and public parks, respectively. This may provide confusion. We believe it would be cleaner and would definitely be less expansive to apply the setback requirement to land owned and managed by the Kansas Department of Wildlife and Parks and land owned by a third party and managed by the Kansas Department of Wildlife and Parks pursuant to the terms of a written agreement. This, for instance, is the land that we lease from the Corps of Engineers around the reservoirs and manage. So it would include those kind of lands. Importantly, we have about 1.1 million acres of walk-in hunting that we lease from private individuals, but we don't manage that. So that would not be included in under our recommendation. That's private land, and we wouldn't recommend that setbacks be applied there as we would for the lands that we own and the lands that we managed. We, on the second page in bold, we say we recommend that wind turbines not be sited within 3 miles of wildlife and parks managed properly. Now, the reason for the 3 mile setback recommendation is based on biological studies out there for a few species in particular. There's some collision risk, not with all species, but with a few when it comes to wind turbines. Whooping cranes are one that we are concerned about, and bats are another. Neither of those are particularly good at avoiding big things up in the air. And so in that we attract those to our managed lands, we'd recommend that 3 mile setback would be enough to give them adequate buffer distance around there. The second is an avoidance risk. Certain species like prairie chickens, and Senator Bowers has these up in her part of the state, and she knows about this. They are ground nesting birds that don't want to get too close to tall structures, and so that 3 mile setback from our areas would also protect them, and that'd be a safe distance. So that's the extent of my comments. We appreciate your consideration for those, and if you'd like to ask questions, I'd be glad to try to answer.
Actually, I think I will open it up to questions for you, and then we'll hold the questions on the opponents until afterwards, so we have plenty of time to ask some questions about their testimony. Anybody on this? Senator Fagg.
Thank you, Mr. Chairman. Thank you, Mr. Lovas, for your presentation. When you look around, have you noticed any wildlife kill out of any of these projects of any magnitude?
I wouldn't say of large magnitude. There's some risk to some species, particularly ones that migrate through. I mentioned bats. That's one we worry about. They tend to fly close to things, and when they fly close to wind turbines, because the pressure drop, they can be killed by those. But we don't see big impacts in the state of Kansas.
You haven't seen the actual dead bats or?
Yep, I've seen them.
Have you?
I have, yep. Yep.
I've read some about insects, believe it or not, and it doesn't seem like it's an important thing, but certain migrating insects can have a huge impact on the ecosystem of the state. Do you have any comment on that?
Yep. I mean, I've seen some studies on the impact to migratory insects. I typically, they're flying at low levels. Birds will migrate at very high levels, oftentimes, sometimes almost passing over the state in migrating. Insects tend to migrate close to the ground, so aren't as effective maybe as some of these species of birds or bats that we're concerned about. But I know there can be an impact.
Any other? Yeah, Senator Francisco?
Thank you, Mr. Chair. This is not a question, but a request. And I'm wondering, Secretary, if you could provide us, maybe you've already done it in Ag and Natural Resources, but with a map of the areas that would be, you've referred to land owned and managed and land owned by a third party. If you could give us that map, and then we could get an idea of what effect the 3 mile limit would have across the state.
We're glad to do that.
Any other questions, committee? One comment, 3 miles is what you asked for around the wildlife section.
Right.
Do you see any incongruence with that and the fact that we're only asking for 1 mile for humans?
Well, I mean, I guess I don't. We're basing ours on scientific studies, and I know you folks are considering science, human behavioral science, and physical science. So we're all looking to the best science we have. My 3 mile recommendation is simply based on the biological science we have on those species that we look out for.
Okay, thank you. Thank you very much.
Thank you very much.
Okay, we'll continue with our oral opponent testimony, next with Kimberly Spotty.
Good afternoon, members of the committee. I appreciate the opportunity to be here before you this afternoon, and I will be brief, recognizing, actually, I'm a little frustrated. We don't have a lot of time. We've got a lot of ground to cover, and we don't have a lot of time, and so we'll just get right into it. My name is Kimberly Swati, and I'm here on behalf of the Advanced Power Alliance. And we are an organization that represents more than 40 different companies, from some of the companies like Trade Wind Energy, which is now owned by Enel, which has 150 jobs in Lenexa, to EDPR, which has their headquarters in Overland Park, their regional development office, to Savion, a solar and storage company with more than 125 staff in Kansas City, Shell, BP, Orsted, Avangrid, Nextera. These are all the companies that build, operate, and finance wind and solar projects, and they are driving investments in the advanced power economy. The advanced power economy, not just being wind and solar, but being hydrogen, nitrogen, fuel cells. We're talking about all of the advanced technologies that are occurring, and they're happening in other states and in different parts of the United States and around the world. We would love to see the jobs and investment happen here. Oklahoma now is known as the hydrogen epicenter of the United States because they put together a task force of groups that met for a handful of times to talk about how do they incent hydrogen to the state. That's all they did. No tax incentives, no nothing. It was just a task force. And now they have a 550 megawatt, up to 550 megawatt hydrogen unit going in there in order to help power light duty trucks because of a task force. So the message that we're now sending is that we're not interested in those companies that are developing wind and solar, but that are also developing the next generation technologies, which are being deployed right now. We're not interested in that investment because, look, after 20 years of operation and 20 years of experience, we're now seeking to do 8 different pieces of legislation that do conflict. They don't mesh well together. There are things in here that are not defined. So this is punitive. This is not progressive. This is not laying out a chart, a path of economic development or growth for the state of Kansas. We're talking about an industry that has invested more than $14 billion in private capital in our state, created more than 20,000 direct and indirect jobs. Yes, yesterday, a conferee mentioned that there were 593 jobs in the state that were constructed. Yes, that's true. Those are on-site jobs. That does not include the jobs in Kansas City. That does not include the jobs at the Siemens Nacelles manufacturing facility, 450, all the component part manufacturers and suppliers that exist. 20 years of operational experience. If there was an issue, I am 100% certain that in years 2, 3, or 5, you would have been hearing about it. The Kansas Farm Bureau has traveled the state educating landowners about how to enter into lease agreements and negotiations. The Kansas Association of Counties every year hosts a variety of different educational forums about the leasing process, not only for the commissioners, tenured commissioners, but new commissioners, to counsel for the counties and other staff. The commissioners themselves talk amongst one another, and they swap stories and they share ideas. In 2005, we created the energy siting guidelines. They were guidelines because after 18 months of deliberation, there could not be agreement reached as to whether or not they were going to put these into statute. It was divided 22 to 22 vote after 18 months worth of work. In 2010, the Kansas Supreme Court upheld the right of counties to upheld the right of counties to make their own decisions, to enter moratoriums or to ban renewable energy development. 2011, a group of us, we all came together to work on the Flint Hills box. It was based on information put forth by the United States Fish and Wildlife Service. And in 2015, the industry came together with folks, again, to reach agreement on the rules of the road of investment in the state of Kansas. And that was a deliberative process. It took months to do, but we did it. We did not do it by introducing 8 different pieces of legislation and having it be a combative situation. And furthermore, all of the parties that were a party to all of those different conversations that changed the rules of the road for the industry in the state, we all did have one goal. We were working to create stability, and we were working to attract that investment into the state of Kansas. So there were a lot of things that were discussed yesterday. I have information before me on the Apex ice throw study, and I'm happy to show it to you right now, talk about the information included in there, none of which was about 3,000 feet of an ice throw, a potential 1 in 200 year event for a possible 300-foot ice throw. We can certainly talk about the $35 million lawsuit that, yes, was filed on behalf of a developer that is not part of our organization. That developer does not exist anymore. That project does not exist in its previous form anymore. Happy to talk about that. And that was because of their tactics, which were not industry represented. Lastly, there was a commissioner here that came, and that came up yesterday. I'd be more than happy to introduce Cole Prail, who is a commissioner in Labette County, Kansas, and has been dealing with the RWE project for the last 2 years. So he is here if you have any questions. I would encourage you to ask questions. Please ask questions of us so we could have possibly some equal amount of time. Thank you.
That's why we allowed this time, and I held it to 5 minutes per testimony, like we did for everybody yesterday. So it would be equal time for everyone and plenty of time for the committee to ask questions, because with opposition comes a lot of accusations and refuting of testimony that was yesterday, so we need the time to consider what you're saying. And this is one bill, not 8 bills. This is Senate Bill 353. We'll have hearings on other bills. You'll have the opportunity to testify on those bills. Committee, do we have any questions? Senator Olson.
I got a question and a comment. Alan, can you answer a question? This bill being retroactive, I'm guessing it's going to be challenged in court, probably deemed unconstitutional. I mean, I've never seen anything at this magnitude be retroactive ever pass, and I'm guessing the state's going to be in for a heavy litigation.
I think that'd be one of the items that would be this for this bill if it were passed as is. That part, if you think about just the massive disruption to unknown, again, the fact that you don't know what disruption that'd be to production, electricity production, retroactive applied to projects already permitted, I would expect that would lend the county or the state into a significant challenge there. But it also disrupts the utilities. So they've entered into agreements with all sorts of different parties. What does it do to those agreements? None of us know. The author doesn't know what that'll do to those agreements. The developers themselves, contracts they've entered into with utilities, with financing parties. What does it do to disrupt those contracts? No one knows. No one knows.
I can tell you there's a lot of 20-year contracts, and it wouldn't be just the developers suing. You're going to have hundreds, if not thousands, of lawsuits. Even the landowners could participate because they're losing out. But I was there in 2015. I'm the guy that negotiated the repeal of the RPS mandate, and I looked around the room. Everybody was in there working together. And I remember Governor Brownback's speech that, he was very proud of what we did, reaching across the aisle, everybody working together. And I think he probably deems this his biggest success, the $5 or $6 billion that was invested after. In my mind, if we move forward with this bill, we are now an exporter of energy. We will no longer be an exporter of energy. We'll be an importer of energy. And
Senator, are you testifying or are you asking a question? We need
I'm
time.
making a comment here, which I have a right, I believe.
I'll limit the time because we do have other people with
Well,
questions.
we had people all week say what they want for an hour, and I sat in here for a long time.
This is my committee, and I'm saying get a
Great.
question in.
I'm on this committee, and I'm just trying to give you a little historical knowledge. It's pretty obvious we'll be an importer of power when you lose all this wind power.
And to the point you've made there, the couple of items. It used to be where industry, the government, all the counties would get together. And that's just one example around the RPS. The second was, of course, around the Flint Hills area. And I always called that was the great Kansas solution. We got people together. Governor Brownback was great in other parties, and you were part of that with the RPS discussions, where we'd get together, there'd be dialogue. And we got solutions that have been working for 20 years. There's been no dialogue on these 8 bills, and specifically this bill that would kill renewable energy. There's been none of that here. And so to your point, you're right. This is exactly the opposite of what we've been doing for 20 years.
This bill gets the floor. I'll be up all day on that.
Sounds good.
This, by the way, this is perspective for new development. It's only retroactive for shadow flicker, which is mitigatable. Senator Peterson.
Mitigatable only by shutting them down, is what the bill says.
Until it's mitigated.
It says mitigated.
Until it's mitigated. Okay. All righty. Senator Peterson?
You can stay standing.
Alan, you stay standing.
Just a quick question. Do you know what the average length of the purchase power agreement is?
I'd say I don't know about the average, I'd say the normal one's 20 years. 20 years.
Senator Olson, or I have a couple for Mr. Olson. You did some studies for Intrinsic that indicated that the setbacks preference should be given to sound emissions of equal to or less than 40 dBA for non-participating. In Oregon, they've set standards at 35 dBA. In Germany, they've set standards at 35 dBA. This is, with the infrasound, we know it can travel up to 2.5 miles. And infrasound has a lot more impact on cardiovascular disease, as was testified earlier in the week. Can you comment on that?
Senator, multiple comments in there. Let me try to take them one at a time. So yes, I used to work for a company called Intrinsic Environmental Sciences. And while I was there, headed up a research group in wind turbines, wind energy, including here when I was in Kansas. You're, I believe, referring to a paper that I believe was published in 2014, certainly one of numerous papers that I published. And there's a series of siting guidelines in there and recommendations. The first of which says that, if you have no siting guidelines, if you're able to come in and walk in and just, put up towers, yes, 40 decibels is a good number to make sure that you're not going to have community objection and support or non-support. Then it has a series of recommendations in there at 45 decibels. I believe there's 5 points. I don't have the letter or the paper in front of me, but there's 5 points, I believe. Second one is 45 decibels. That should then go in front of things like community ordinances and county commissions in order to make sure that the local officials are going to be on board. And I believe that paper states that you should not site wind turbines over 50 decibels. And those are exactly the same rules that I've talked about throughout. Germany does not have a 35 decibel sound limit, Senator. I can guarantee that that is not the case. There are some areas within Germany where that might be applicable, but they actually have sound standards of over 40 decibels. And then in terms of cardiovascular disease, with all due respect to Dr. Johnson, he's come to this over the last 3 years. He has not published in this area. He did not put in front of this committee all of the work that has been done looking at specifically cardiovascular disease, blood pressure, hypertension, medications of people living around wind turbines for the last 20 years. When we do those studies, when those studies have been done by Health Canada, in the UK, in Australia, here in the United States itself, you've heard no mention of the Lawrence Berkeley National Laboratory that was funded by the Energy Board in order to do those studies. We have the studies. Those studies do exist. You have 20 years of experience here in Kansas of sound levels between 45 and 50 decibels, and those work. You don't have people coming and testifying saying that they've got cardiovascular disease and others. So the setback distance challenge, there's a whole lot more. It's not an easy topic, and I don't mean to make light of it at all.
Are you talking, the 45 dBA, was that LEQ?
It's an LEQ, yes. So,
So LEQ is an equivalent, consistent sound measurement which ignores the peaks in the valleys.
No, Senator, it doesn't. There are peaks and valleys, and that's why you have an average. And the reason we have that, Senator, is because when you look at sound and you look at the health effects of sound and you look at how we're measuring it, it's either over a 10-minute period, an LEQ, or a 1 hour. There is not a jurisdiction, unlike you heard from Mr. James and Dr. Punch and Dr. Johnson. If you go to North Dakota, South Dakota, I'm going to a Nebraska County hearing right after this for this evening. We set these sound limits on an LEQ basis, just like we do for other noise sources, because that's the appropriate metric that we use. It doesn't ignore the peaks. The peaks occur, and they're averaged out then over a very short time period. So, and then in terms of infrasound, low frequency noise, no, there actually isn't. The research done on low frequency noise and infrasound, not just around wind turbines, but in general, is very, very emphatically that no, the levels we're talking about from wind turbines, absolutely. We can measure infrasound low frequency noise from turbines. I could measure it in the room right now because you've got an HVAC system going on. We have infrasound, it's in the room. If any of you drove here, unless you live like around the block, which some of you might, the infrasound you experienced in your car is far greater than you would have even at a maximum around a turbine. And you don't have to just believe me, Senators. Like I've got quotes in here, for example, from the Germans. Senator, you mentioned the Germans.
I've got some questions though for you.
So very quickly, from the German study that I quoted for you, a state level government in Germany says, together with the health authorities, we in Baden-Württemberg have come to the conclusion that adverse effects relating to infrasound from wind turbines cannot be expected on the basis of the evidence at hand. So this is not something new, and it is not something that is posing a health threat.
So with regard to the LEQ, so the committee understands, if you were stopped by the police doing 100 miles an hour, you would then argue to the police that your average speed was 50 miles an hour because at one point your car was stopped.
No, Senator.
Because that's how LEQ works. It's an average, and a 10-minute average does not capture the peaks.
And
In fact, I have a
Senator,
study from Rand.
Yes, Rob Rand.
Robert Rand.
And it's not published, so what's the study from Mr. Rand that you have there?
Study from Rand that indicates that the only proper way to find the peaks, because there's a difference between consistent industrial noise like car noise, traffic noise, and the pulses created by a wind turbine. There's completely different noise, and that noise, the creation of the infrasound happens at levels that are below the levels of audibility. Do you have a degree in acoustics?
No, sir.
You have a degree in medicine.
I have a PhD in environmental health, and this is what I get paid to do. This is what I've been qualified by courts and testified in.
So are you qualified? Are you qualified to make a statement that these are unsafe or that these are safe?
Senator, if you actually look at my testimony says that you do need proper setbacks. You do need proper sound limits in order to ensure the safety of public safety. The study you're referring to from Mr. Rand, a number of his rantings that he's done over the years. These are not studies that have been adopted by your fellow states. They're not studies that have been.
Oregon set 35 dB.
Oregon, it's not as simple as 35 decibels in Oregon, Senator. There's a number of different ways that Oregon looks at it in terms of 35 is the basement, and then you can add sound decibels to that depending on where you are, what the background sound level is like. There's not a project cited in Oregon just right to 35 decibels. So, but in terms of again, to come back to this, Senator, I don't mean to argue with you. I really don't. It is an emotionally charged issue, but it is one that has 20 years of science behind it. You heard from 3 individuals that are on the fringe of this, where New York State did not adopt their testimony when they recently set their siting guidelines. It has not been adopted by other states. Again, you don't have to trust just me, Senator. You can look at your fellow states that have state-level legislation. None of them come anywhere close to what you have here.
But in this case, and I'll open it up to any other questions here after this, the wind industry is setting the setbacks of 1,500 feet for the wind industry. There are no states, there are individual counties, but you go into counties and these county commissioners are not equipped. And from what I've heard, and I've done plenty of research, so if the wind industry is setting the 1,500-foot setback for the wind industry, it's feeding that information to county commissioners.
So, Senator, like any topic, and it's simply not true that it's only counties that have 1,500 feet. In North Dakota, in their state statute, they have a 3 times turbine height setback distance to non-participating homes. Do local counties, do we have discussions with them over, I've been in some of your counties 5, 6, 7, 8 times during ordinance hearings and CP hearings to work collaboratively to understand what the issues are. It's not just a industry says 1,500 feet and walks away. You have counties, and I would disagree with you that local county officials are not equipped to do this. I mean, you've got county officials that have set a 2,500-foot setback. You have others that have a 1,500-foot setback. There are some counties in the Midwest that still have a 1,000-foot setback that I certainly would never tell you that you should put a turbine, one of the modern turbines, 1,000 feet from somebody's homes. So there are, again, when you look at other statutes, you look at other states that have state-level guidance and codified into law. You can't build a turbine in North Dakota that's less than 3 times turbine height to homes. You can't go to New York and actually build a turbine just wherever you want. These are, many years of testimony in front of committees like this, but also then, learned testimony on both sides, many hours, and usually in front of public utilities commissions.
3 times turbine height would be 1,500 feet.
It depends on the height of the turbine. No, right. Senator, I mean, I work.
Oh, a 300-foot turbine would be 900
I work on projects that there's 650-foot turbines now. Yeah. So 600-foot turbines, not unheard of at all these days. In fact, most of them are about that. So that'd be 1,800 feet.
Okay. Thank you. Thank you.
Welcome, sir.
Questions? Senator Francisco.
Thank you, Mr. Chair. So I'm not sure anybody could answer how flicker can be mitigated but if you can. And then I see in your attachment A that it refers to some quotes on health effects, but also suggests a no more than 30 hours of shadow flicker at non-participating residents has been adopted some places. Could you?
Yes, Senator, no, absolutely. So first of all, the no more than 30 hours of shadow flicker, an actual shadow flicker, that actually was an old German standard that then more or less became adopted by many states and local counties here in the U.S. The way that you mitigate shadow flicker, you can do it in a number of ways, is that you can do things like put hedgerows in for people, trees around their homes, you can buy them blinds, but the ultimate way to mitigate shadow flicker is to shut them down. But the difference between what's contemplated in this bill versus what we actually do is that shadow flicker is something that we have at people's homes, not at their property line. So if the shadow flicker is in the home, the shadow cast over the window causes a flicker in the home. When you're standing outside, you've got a rotating shadow just cast on the ground. They're not the same thing. You can mitigate. So in many of the jurisdictions that I work with, you can mitigate, you say that you can allow no more than 30 hours of shadow flicker at a non-participating home. Beyond that, which might be 10, 15 hours perhaps, so maybe you're at 45 hours. Beyond that, for 15 hours a year, let's say it was 45, 15 hours a year, you have to shut it down. And that is absolutely reasonable and can be done and should be done. The difference between that and what's in Bill 353 is it says no shadow flicker on your property ever. So what this does is that there could be hundreds of hours, potentially over the course of a year, 4,000, 5,000 hours of daylight hours in a year, there could be a couple hundred hours where the cattle are grazing, we're going to limit it to no shadow flicker where the cattle are hanging out, or corn growing. It's unreasonable. And what that does is that it takes there's no health basis for it, there's no basis for the cattle or any livestock, and certainly not for the corn. But then what that does is it takes out of production so many of those hours, and that's not my role, but there's no other jurisdiction that I'm aware of that limits shadow flicker to 0 at property lines, or even 30 hours for that matter, Senator.
Just one quick question. Thank you.
Yes.
One quick question for Mr. Anderson. On the state statute 74-7284, this was established by the state legislature and said the purpose of the state government is to keep secure the constitutional rights of Kansas citizens to protect their health, safety, and welfare. We have scientific evidence that shows 1,500 feet is too short. And we also know that wind companies, some wind companies, I don't know if you've been party to this, have intervened in other counties. We heard about it yesterday from Marion County. And one of the tactics, of course, is to depose with the voluminous money of these billion-dollar wind companies until these small communities run out of money and then they give in. Is this the common tactic that we're going to expect in the state of Kansas?
So the first part, we do not have any evidence that 1,500 feet is too little. That's the first part. That is absolutely not true. So if we're thinking about protecting health and safety, that's where we need to start, is we need to use real science and real engineering to look at that. So that'd be the first point.
Okay. Jade, can we pull up a video very quickly? I want to show you, you didn't see this from yesterday. You weren't here, did you?
I saw it.
For anybody in the room who didn't see this, I'd like to replay this and ask you if this would make you comfortable living 1,500 feet away. 1,500 feet, remember, is 5 football fields. That's all. I'm not sure how tall that turbine is, but we know the apex study ice throws is over 3,000 feet, and I have a copy of that in my office.
And I think you'll see it doesn't say that now. So this is a good example. So what we have here is an emergency event. Obviously, a turbine has had an issue. At that point, if my house was on fire, I would expect my neighbors to probably get a little further away. We will have extraordinary events that take place, and we'll need a larger area. You can take a look in the picture. No one's being hurt there. That's an unfortunate event where there's a fire. And that would have been, and as you can see in there, there's nothing around it where it took place. The emergency services would do what they need to do. In the rare event that this takes place, same thing when you have a car fire. If someone's sitting in my car and we're moving down the road, it works quite fine. If my car's on fire, I would expect you all to get a little further away.
Right.
Extraordinary events happen. Sure. That's not how we do
But
stuff.
the homes are already there. The
And-
home's
and-
500 feet. There are some homes in the state that are 600 feet from one of these turbines.
I don't know of any. You'd have
Yes,
to
we
point
had
those
testimony of
to-
that yesterday.
Well, I'd
We-
like to see
committee-
because I don't think that's
Okay.
correct. So your second part of that was, do wind companies, do you want me to answer that or you, okay.
Go ahead.
The second part of that was related to litigation, I guess.
Right.
And so, first of all, it's extraordinarily rare, but the fact that we have courts in every county in our state means that sometimes everyone will need access to the courts. There's individuals who had lawsuits, as I understand, I'm not part of that one you talk about, that have had lawsuits. We have the freedom. This is where I know we want to take the freedom of contract. I know we want to take away people's property rights, but we also have the freedom to, if there is a grievance, people have access to the courts, whether that's individuals or whether that's companies.
But
We have an orderly
it is
process.
after the fact. Once a home is there and a turbine pops up right next door, you can't move your house, correct?
Say that again. Once
Once a home is in place and a turbine is sited next to your house, it's pretty expensive to move your house.
That's right. And so if someone has a turbine in a location that creates the nuisance that that was mentioned yesterday as well, they have access to the courts. If someone cites a turbine where it is actually creating a health or safety or nuisance issue, that would be a problem for the company that put the turbine there, and they would have access to the courts to go do that. And that's when I get to the point of they are cited safely. We know that, or you would have all heard about this. What we're talking about is mythical land that these things have taken place. That's not the case. Again, with 20-year history, and that wasn't the case of people's testimony yesterday. There were people that were dissatisfied with their county commissioners, or in some cases the cities, didn't do what they wanted. But more people in their county wanted the project to move forward. That's where they were dissatisfied about it.
And in this case, it's the wind company dissatisfied with what the state is about to do. Thank you very much. We're out of time. Committee, we are adjourned. And we will close the hearing on Senate Bill 353. Thank you.